Hi everyone, this is Ryan with the OKFD again, coming back to you for our 5th installment of our video resource series for special needs families. Thank you for joining us. We're going to jump right in here today. This video is about special needs trust. What are they? How do you get them? Do you need one? So we're going to hop right into it. What is a special needs trust? A special needs trust is a legal arrangement that lets a physically or mentally ill person or someone chronically disabled have access to funding without potentially losing the benefits provided by public assistance programs. A special needs trust, or SNT, sometimes referred to as a supplemental needs trust, is a legal vehicle which enables assets to be held on behalf of someone with disabilities without affecting their eligibility for means-tested public benefits such as Medicaid or supplemental security income. A special needs trust, sometimes referred to as a supplemental needs trust, is a legal document which enables assets to be held on behalf of someone with disabilities without affecting their eligibility for public benefits such as Medicaid or supplemental security income. While assets held by the trust are not countable for the purpose of qualifying for these programs, there are strict regulations regarding disbursements. So SNTs, or special needs trusts, are meant to supplement the funds and services available through government programs, not to replace them. What responsibilities does a trustee have? Administering a special needs trust is considerably more complicated than managing most other trusts. The trustee is responsible for investing funds, making disbursements, paying taxes, and maintaining detailed accounts and records. This requires an understanding of government programs, including strict regulations concerning the use of special needs trust assets, and from now on I'm just going to call them trust assets since everybody knows we're just talking about special needs. Since improper use of the funds can disqualify the beneficiary for important qualified public benefits, in addition to handling these technical requirements, the trustee should have a deep appreciation for the beneficiary's needs and desires so that the trust will make the best possible contribution to the individual's quality of life. There are two types of special needs trusts, commonly designated as first party and third party. It is important to determine which type of trust you have or need. This depends upon whose property is actually funding the trust itself. If the property funding the trust originates with the trust's beneficiary, then it is a first party trust. However, if the property funding the trust always belong to someone other than the desired beneficiary, then it must be drafted as a third-party trust. Third-party special needs trusts, what are they? They are commonly used by persons planning in advance for a loved one with special needs. Typically, the parents of an individual with disabilities or special needs will be the persons who establish a third-party trust. Although a grandparent, a sibling, or any other person other than the beneficiary may establish the third-party special needs trust. Third-party trust can be included in last will and testament, also known as a living trust, or drafted as a standalone trust. These trusts are typically funded upon the death of the beneficiary's parents or other individuals who established the trust in the first place. Trusts created under a will or as a subtrust within a living trust do not come into existence and therefore cannot receive gifts until after the death of the individuals whose will or living trust created the SNT. Therefore, a standalone SNT may be more useful if there are multiple donors who wish to fund the trust. A standalone SNT exists during the lifetime of the person establishing the trust, which allows the special needs trust to receive gifts from grandparents, family, friends, or even the person establishing the SNT themselves prior to the death of the trust's creator. Such a special needs trust is available as a receptacle for lifetime and post-mortem gifts from any third-party source. This type of trust does not have to be irrevocable in order to preserve the eligibility of the beneficiary for means-tested qualified public benefits. However, if the special needs trust beneficiary has the power to revoke the trust assets would be considered an available resource for supplemental security income and Medicaid purposes. The beneficiary's ability to revoke the trust or otherwise exercise control over this trust may render the beneficiary ineligible to receive public benefits that have an income or asset limit like SSDI. The trust agreement should authorize the person establishing the third party and or the trustee to amend the trust to address later changes in the law or the circumstances of the beneficiary. Allowing for such limited amendments helps ensure that essential government benefits are preserved if an agency challenges the terms of your trust. The most important difference between third-party trusts and first-party trusts is what happens to trust property when the beneficiary dies. So upon the beneficiary's death, the original creator of this trust, the third-party trust is not required to use the remaining assets to reimburse any state for the Medicaid benefits received by the beneficiary during his or her lifetime. As a result, this type of trust is a useful planning tool for people who want to set aside property for a beneficiary with disabilities, preserve essential public benefits during that beneficiary's lifetime, and remain in full control of where all the remaining trust assets will go upon the death of the beneficiary. First-party special needs trusts are most often used when the person with a disability inherits money or property outright or receives some type of court settlement. These SNTs are also useful when a person without a prior disability owns assets in his or her name, later becomes disabled, and thereafter needs to qualify for public benefits that have an income or asset limitation. These trusts are creatures of federal law specifically until the Special Needs Trust Fairness Act became law late in 2016, and you heard me right, not 1916, 2016, the only person or entities authorized to establish an individual first-party SNT were the trust beneficiary's parents, grandparent, legal guardian, or a court. Since December 13th of 2016, however, federal law also authorizes a mentally and legally competent SNT beneficiary to establish an individual party trust. A first-party trust is funded with property that belongs to the beneficiary or to which the beneficiary is or becomes legally entitled to. Property in a first-party trust can only be used for the sole benefit of that beneficiary. Individual first-party trusts may be created and funded only for individuals who meet the government's definition of disabled and are under 65 years of age when the trust is established. While a pooled first-party trust can be established by individuals over 65 years of age in many states, a significant number of states do not allow a person over age 65 to establish or transfer property to a pooled first-party trust without massive penalty. Pooled first-party trusts can be established by the beneficiary's parents, the grandparents or guardian, or a court. If the trust beneficiary is not mentally and legally competent, then court approval must be obtained to fund the trust with the beneficiary's property. All first-party trusts must specify that after the beneficiary's death, all amounts remaining in the trust, up to an amount equal to the total lifetime medical assistance benefits paid on behalf of the beneficiary by the Medicaid program of any state, are first repaid to those states, even to the extent of fully exhausting the remaining trust assets. Only after this Medicaid payback may any balance be distributed to other remaining beneficiaries. A legally competent person with a disability may have a first-party SNT established and funded without court involvement. However, annual accountings should be provided on an informal basis to the beneficiary and to the applicable Medicaid agencies. So when a minor or mentally incompetent adult is legally entitled to receive funds from a lawsuit, an inheritance, or from any other source, then court approval to establish and fund the first-party trust is required. Often the court must make specific findings to ensure that the trust is considered exempt when determining the beneficiary's eligibility for public benefits that have income or asset qualification thresholds. These findings could include the following. The minor or adult has a disability that substantially impairs the person's ability to provide for his or her own care or custody and constitutes a substantial handicap. These are not my words, these are the government's words. In practice, a person who qualifies for SSI or Medicaid on the basis of disability is likely to satisfy the substantial impairment requirement. The minor or adult is likely to have special needs and expenses that will not be met without setting aside assets in the trust. The property used to fund the trust does not exceed the amount that appears reasonably necessary to meet the special needs of a minor or adult. And there's one of my favorite words in there. It appears reasonably necessary. Basically, that means that each single trust is separate and treated as an individual case. So reasonably apparent. Pooled special needs trusts programs can be used to establish both first-party and third-party trusts. Pooled trusts are established and administered by a nonprofit association for the benefit of multiple beneficiaries. Pooled S&T programs have the following features. A separate account is maintained for each individual beneficiary of the pooled trust, but the administrator pools the assets of all accounts for purposes of investment and management. A master trust agreement governs the separate accounts of all S&T beneficiaries pursuant to a joinder document. An account with the pooled S&T is established for the sole benefit of an individual with disabilities. This is established by the parent, grandparent, or legal guardian of the individual, or by the individual personally, or of course, by a court. The beneficiary of a first-party account must meet the government's definition of disabled. Easiest way to know if you meet those requirements is if you're already receiving SSDI, SSI, or Medicaid, Medicare. While there is no express prohibition against establishing and funding a first-party account with a pooled trust if the beneficiary is 65 years of age or older, most states do impose an eligibility penalty in that situation, and some of those penalties can be pretty hefty. So check with your individual state for details. For first-party accounts with pooled S&Ts in all states, any assets remaining in the beneficiary's separate account upon his or her death to the extent not retained by the pooled trust first must be used to reimburse Medicaid, like we've already talked about, plus any expenses due to Medicaid in that particular state that has provided medical assistance to the beneficiary. However, a state is not entitled to receive more than the amount remaining in the beneficiary's separate account, even if the amount owed to the state is greater and much greater than the amount remaining in the deceased beneficiary's separate account. Basically, you can break even. You can walk away clean in that event. So I gave you a lot of information about special needs trust, about different types of special needs trust. I know it's a lot of legal information. Please consult an attorney. We are not lawyers. We are not giving legal advice. We are simply giving you advice. So reach out to your attorney, ask all of the questions that you have. If you don't have an attorney and you need to find one, the easiest way, of course, is to Google special needs trust attorneys, or in some states, just type in non-profit attorneys. Maybe you already have one. They can certainly direct you to a professional or an expert that can help you navigate this process. It is critical to get a special needs trust if you believe that your loved one with special needs will someday receive an inheritance, will someday need an additional money or income, or that maybe a grandparent or a loved one or a friend of the family is going to leave money behind for them. They can't just will it to them. You need to protect that money, make it go as long as it possibly can. That is the purpose of a special needs trust. It's one of many things that you need, but it is a big one. They are not inexpensive. They are very expensive, but there are a lot of attorneys out there that will do things pro bono or for a discounted rate. A lot of this stuff can be done by the individual, by making runs to the courthouse, by doing things online, arranging all of this documentation and paperwork. So you can substantially decrease the cost of a special needs trust by doing some of the legwork yourself. So keep that in mind. I hope you guys found this information useful. If you have any questions, comments, or concerns, as always, please leave those on this video. Check our website. There's a comment and questions box there as well. Thanks again for joining us. Really appreciate it. Please remember to like and comment on this video if you have any questions, comments. Of course, if you have any suggestions for future videos, please drop those in the comment box as well, either on this video or on our website. Our next video series, which will be coming up in a few days, is going to be about guardianship, all types of them and why you need them. So look forward to that. Thanks again for joining us. Stay compassionate. See you later.